Hey y'all, I'm the Loud Little Ducky. Today we are going to jump into Sandra Birchmore, the civil lawsuit. We have already gone over an overview of her story and covered the internal investigation. So now we're going to go into the civil lawsuit where the family is suing Stoughton Police Department. Let's jump in. Commonwealth of Massachusetts. This was filed in December 29th, 2022 in the Superior Court of Norfolk. And it's Darlene Smith as the personal representative of the estate of Sandra Birchmore. She is Sandra's aunt, her aunt, however y'all say it. And it is versus the individuals of Matthew Farwell, William Farwell, and Robert Devine, and they're going to go after the town of Stoughton and the Stoughton Police Department. Now I don't know what the town necessarily is, but just put them all under there. And if you have to dismiss some of the defendants, then you do so. Complaint and demand for a jury trial. Nature of action. A. This is an action brought by the plaintiff Darlene Smith as the personal representative of the estate of Sandra Birchmore, hereinafter referred to as plaintiff, for wrongful death, negligence, negligent supervision, negligent retention, pain and suffering, and emotional distress as against the defendants Matthew Farwell, William Farwell, Robert Devine, the town of Stoughton, and the Stoughton Police Department, hereinafter referred to collectively as defendants, for claims arising out of an ongoing scheme of grooming Sandra Birchmore, hereinafter referred to as decedent or Miss Birchmore, and the misconduct that ultimately led to the loss of Miss Birchmore's life on February 4th, 2021, after the defendants Matthew and William Farwell and Robert Devine, hereinafter collectively the officers, undertook to engage in appropriate relationships with the decedent, who was a minor when the sexual relationships were initiated, abusing her trust and adoration of law enforcement, which through their inappropriate and undue influence ultimately led to her allegedly taking her own life. B. Plaintiff brought this action against Stoughton, the town, referred to as Stoughton, and the Stoughton Police Department, herein referred to as PD, for claims arising from the conduct of its officers and its negligence in its supervision of said officers over the duration of Stoughton Police Explorers Program and thereafter. Going into jurisdiction and venue. Norfolk Superior Court has jurisdiction over the claims asserted herein pursuant to MGL C 212-3. Venue is proper in Norfolk County pursuant to MGL 223. Parties. The estate of Sandra Birchmore is a probate estate, says the docket, for which Darlene Smith was appointed as the personal representative on July 12, 2021. Defendant Matthew Farwell, hereinafter M. Farwell, is an individual residing upon information and belief. Defendant William Farwell, or W. Farwell, is an individual. Robert Devine, just going to be considered Devine, which he is not. Defendant Stoughton Police Department, gives their address. Defendant Town of Stoughton is a municipality located in Norfolk County with its municipal building. All right, facts. On February 4th, 2021, the Canton Police Department responded to a welfare check at the decedent's apartment, located in Canton, Massachusetts, following a request from her employer, who was justifiably concerned as she had not reported to work for several days. It was during this welfare check that the body of the decedent was discovered, and she was pronounced dead at the scene by the responding paramedics. At the time of her death, upon information and belief, Miss Birchmore was 3 months pregnant with her first child, allegedly by one of the officers. Miss Birchmore's death was the culmination of a near decade-long scheme of grooming. And as footnote 1 says, grooming is a method used by offenders that involves building trust with a child and the adults around a child in an effort to gain access to and time alone with him or her. In extreme cases, offenders may use threats or physical force to essay or abuse a child. More common, though, are subtle approaches designed to build relationships with families. The offender may assume a caring role, befriend the child, or even exploit their position of trust and authority to groom the child and or the child's family. These individuals intentionally build relationships with the adults around the child or seek out a child who is less supervised by adults in his or her life. This increases the likelihood that an offender's time with the child is welcomed and encouraged. Understanding sexual grooming in a child abuse cases, you can go to theamericanbar.org. I will link that below. Okay, so that was footnote 1. So the grooming and repeated essays from a young age by a certain police officers employed by the Stoughton Police Department. Descendant from her youth, suffered from a difficult home life. She struggled as a child with the loss of her grandmother and mother, and as she grew up, dealt with some significant mental and emotional problems for which she sought psychological care from adolescence into adulthood. Despite these issues, Miss Birchmore deeply respected authority figures, most notably police officers. As a result of this admiration, she joined the Stoughton Police Department Explorers Program, herein referred to as program, in her early teenage years. It was through this program that the decedent was introduced to defendants Devine and the twin brothers Matthew and William Farwell. The defendant, Devine, was the head of the program, and defendants Michael and William Farwell, or Matthew, not Michael, get the names right. Matthew Farwell and his twin brother William Farwell both worked with the program in their individual capacities as officers and educators. Matthew Farwell was seen on video surveillance at Birchmore's apartment approximately 4 days prior to the discovery of her body, and upon information and belief was the last person to see Miss Birchmore alive. It was later revealed by the Stoughton Police Department's internal investigation report that Matthew Farwell had known the decedent since age 13. So he's known her for about 10 years, because she was 23 when she passed away. From her participation in the Explorers Program, and soon thereafter began an asexual relationship with her when she was 15. So he kind of groomed her for 2 years. The investigation revealed that Matthew Farwell had continuous sexual relationships with Ms. Birchmore that started while she was still a minor. The same investigation determined that Matthew Farwell later used some type of location sharing application to track and determine Miss Birchmore's location. That is not your child. You do not need to be tracking a minor child. You're not doing it for her safety and her protection, because you wouldn't do it for anybody else. Otherwise, you would do that for all the children, and that's still creepy. You have no business knowing her whereabouts. And she can't consent to that, even if she said, yeah, sure, I'll share. Because he probably was like, oh, just to make sure that you're safe, and, you know, if you ever need help, I know where you are. Yeah, that's creepy. And they may think it's sweet and safe and everything like that, and it's not. It's creepy. And I don't care if she's 15 or 16. And in Massachusetts, 16 is of age, of consent there. It's still not okay at 16. I don't care what the law says. The police department's internal investigation determined by a preponderance of evidence that defendants William Farwell and Devine had similar sexual relationships with Miss Birchmore, and that both had repeated contact with the decedent while on duty. And we do have a video out that talks about, the laws and rules kind of thing that you are supposed to follow as a police officer, with a badge and stuff. And you're not supposed to be doing all that while on duty, even if it's with your wife. The same investigation determined that not only did all three of the officers have sexual relationships with Miss Birchmore, but that Devine effectively established that the Farwells, as his understudies in using their position, had influence while on duty to engage in inappropriate behaviors with minors during the program and with the decedent. It was this ongoing pattern of abuse and behavior over the near decade-long relationship that created and exacerbated the underlying trauma, mental, and emotional distress suffered by Miss Birchmore that ultimately overwhelmed the decedent's will to live and in turn caused her death. Each count contained herein is derived of the sexual abuse of the decedent as a minor while she was participating in the program. And before we jump into that, I think the reason that we have to do civil is because these men cannot confront their accuser because she's no longer alive. And it stinks that these guys get away with that aspect. It really does. Because they should all be in jail. But Matthew Farwell shouldn't just be in jail because of sexual encounters with minors, but also possibly murdering somebody. But did he do it? That's why we need to continue looking into this case and seeing what all is out there. There's a lot that points to him. But it'll be really interesting when this stuff finally does go to trial in the civil suit, for sure, because a lot's going to come out. So, wrongful death. Plaintiff's estate versus defendants in Matthew Farwell, William Farwell, and Devine. The plaintiff restates and incorporates by referencing paragraphs 1 through 14 as if fully set forth herein. On February 4th, 2021, Ms. Birchmore was found to be deceased following a welfare check by the police. The last person to have seen the decedent alive several days prior was Matthew Farwell, who was seen on video surveillance at Miss Birchmore's approximately 4 days prior to the discovery of her body. Upon information and belief, was the last person to see Miss Birchmore alive. Decedent, age 13, grooming 15. Okay, this is kind of stuff just repeated. Preponderance of the evidence. They did it while they were on duty. Used their position and influence in inappropriate behaviors with minors during the program with the decedent while they were on duty. It was this ongoing pattern of grooming, abuse, and inappropriate behavior by Devine, Matthew Farwell, and William Farwell over the near decade-long relationship, the duration of the program, and beyond, beginning when Miss Birchmore was a minor. that created and exacerbated the underlying trauma, mental, and emotional distress suffered by Miss Birchmore and subvert her appreciation and adoration for authority figures, namely the officers she idolized, through the campaign of inappropriate and undue influence resulting from the officers' actions as such authority figures. Although the decedent had underlying mental health issues, it was this ongoing, years-long pattern of grooming, abuse, and inappropriate sexual behaviors by Devine, Matthew, and William Farwell that exasperated Miss Birchmore's mental health and was the underlying trauma that ultimately overwhelmed the decedent's will to live and in turn caused her death. Okay, this is interesting because at this point they are still under the assumption here that Sandra had unalived herself. Now they have a little bit more information, so they're saying that the grooming behaviors and abuse and all that caused her to do this. I don't know if they have since taken this away and amended it, because I would be putting alleged in there. Or that, but we'll see where this goes throughout and see what else comes out. Because as I said, this is from December 29th, 2022, so we'll be looking at things past that to see if things changed and such like that when they got the medical examiner for their case and all that. Because this was written before they got to, I guess, discovery and stuff, probably. So we'll see where this ride takes us. But in this, they are under the impression that she unalived herself due to the things that these men's did. All right. The defendants intentionally caused harmful and offensive sexual contact with Miss Birchmore, a minor at the time, and it was those offensive contacts that continued well after her participation in the program, which directly resulted in the death of Miss Birchmore. The officers knew of the offensive nature of their contact with the decedent, especially when she was a minor, and all three officers acted willfully and wantonly with the intent to conduct such sexual conduct. But also, if she struggles with mental and emotional problems, does she have a childlike mind? And if she does, it may not necessarily fully be able to give consent in certain matters. But she wasn't, she just suffered with things. She wasn't, I don't know the proper terminology to use, but I don't know that she had any learning or developmental type issues. And how many of us struggle with some mental health issues, whether it's depression, anxiety, different things like that, and more. So, as a result of the grooming and abuse and inappropriate sexual conduct, the decedent suffered significant damages due to continuous mental and emotional abuse and trauma that ultimately led her to her alleged unaliving. So at least they say alleged there. And you have to remember, this stuff is on top of her losing people that really mattered to her. So she's probably clinging on to people or trying to fill the voids. And these officers were like, we'll fill the void in more ways than one, which is disgusting and sick. This continuous pattern of grooming, inappropriate behavior, and sexual contact over many years was wanton and reckless, and ultimately overcame Miss Birchmore's will to live and resulted in her alleged unaliving. Glad they're stating alleged here. Wherefore, the plaintiff prays that judgment be entered against William Farwell, Matthew Farwell, and Robert Devine for wrongful death in an amount that will fairly and adequately compensate for the loss of Miss Birchmore's life, and all other damages recoverable together with interest, cost, and such other relief as the Honorable Court deems appropriate. Count 2. Negligence. Plaintiff's estate v. defendants Matthew Farwell, William Farwell, and Robert Devine. The plaintiff restates and incorporates by reference paragraphs 1 through 26 as if fully set forth herein. In addition, the plaintiff states that this count 2 is derivative of count 1 and is derivative of the sexual abuse of the decedent as a minor while she was participating in the Explorers program. Matthew Farwell, William Farwell, and Devine owed Miss Birchmore and the other members of the program a duty to protect this vulnerable class of minors from the very sort of abusive and grooming behavior conducted by these officers. W. Farwell, and Devine breached that duty of undertaking their inappropriate actions against Miss Birchmore. Moreover, these defendants, due to their positions as officers and educators within the program, held a special relationship with Miss Birchmore and other children in the program. This special relationship also created a duty to Miss Birchmore and the rest of the children within the program. It was this willful and wanton breach of duty, trust, and confidence on the part of M. Farwell, W. Farwell, and Devine that ultimately led to the death of Miss Birchmore. Started as a child with other children just alongside her, of her age, maybe a little younger. They were entrusted into these disgusting pigs. They were entrusted. These people trusted them with their children, and these pigs took advantage of it. Wherefore, the plaintiff prays that judgment be entered against the defendants M. Farwell, W. Farwell, and Devine for negligence hereunder in an amount that will fairly and adequately compensate for all damages recoverable together with interest, costs, and such other relief as this honorable court deems appropriate. So they're not asking for a dollar amount. What do you think, dollar amount wise, even comes close to this? She has been preyed upon for around 10 years before her death. She was a child when all of this started. And without these 3 men grooming her in the Explorers program, we would not be sitting here today covering this case, because Birchmore would still be alive. How do you put a price tag on that? It's going to be a lot, and these men should have to pay. They should be in jail and have to pay money. Count 3, negligence. Plaintiff's estate v. defendant Devine. The plaintiff restates and incorporates by reference paragraphs 1 through 31 as if fully set forth herein. In addition, the plaintiff states that this count 3 is derivative of count 1 and is derivative of sexual abuse of the defendant as a minor while she was participating in the program. Devine, through his position as head of the program, owed a duty of care to the decedent and the rest of the explorers due to the special relationship created by that supervisory position. He was the main guy in charge. He allowed all this to happen, but he likes little girls too, because he's been caught with more than one. The court has held that while the public duty rules limit liability of governmental units, a special relationship such as that special relationship with the children participating in the program creates an elevated duty to protect those children rather than the public at large. Devine, as the head of the program, breached this duty to Miss Birchmore by failing to protect her from the conduct of the Farwells, despite his knowledge as to the misconduct occurring at the time. By failing to protect the decedent, Devine breached such special duty, causing her damage and ultimately contributing to her death. Wherefore, the plaintiff prays that judgment be entered against the defendant Devine for negligence in an amount that will fairly and adequately compensate for the loss, pain, and suffering, and all other damages recoverable herein under, together with interest, costs, and such other relief as this honorable court deems appropriate. Count 4. Negligent hiring. This is the plaintiff's estate of Sandra Birchmore versus Stoughton PD. The plaintiff restates and incorporates by reference paragraphs 1 through 36, as if fully set forth herein. In addition, the plaintiff states that this count 4 is derivative of count 1 and is derivative of sexual abuse of the decedent as a minor while she was participating in the Explorers program. Under Massachusetts law, employers whose employees are brought into contact with members of the public have a duty to exercise reasonable care in the selection and retention of their employees. Yeah, there was no care given here. As an employer's knowledge of past acts of impropriety, violence, or disorder on the part of the employee applicant is generally sufficient to forewarn the employer who selects or retains the employee that the employee may commit such an assault during their employment. Stoughton and the police department knew or should have known of the propensities and history of both Matthew and William Farwell due to the requisite rigorous nature of the background checks prior to becoming a police officer. So they should have known about their not so great behavior prior to becoming a police officer. Now, I can say that there are people that are police officers who became police officers because they don't want kids or teens or young adults, a lot of them, doing the same stupid stuff that they used to do that used to get them into trouble. I know some kids that tore up the town and were always in trouble that ended up turning their lives around and becoming police officers. But you need to keep an eye on these people if you are going to hire them. What is their life like now? Because this should have been discoverable. People knew and said nothing. Stoughton, the police department, and Devine, who served on the hiring committee for Matthew Farwell and as the supervisor of the program, knew or should have known of the instances of misconduct on the part of the Farwells both before and during their employment. Such conduct included both Matthew Farwell and William Farwell allegedly impersonating police officers and pulling cars over as teenagers, exercising abuse of trust of authority that accompanies the roles of the police officers. Although Devine has previously denied any such knowledge of the behavior as per the police department investigative report, however, such a lack of knowledge as described by the same report would be impossible, as Devine was the head of the program and was familiar with both Matthew and William Farwell and sat on the hiring board for Matthew Farwell. Additionally, as the investigative report states, the prior acts, including the impersonation of police officers by both M. Farwell and W. Farwell were widely known throughout the department. Yeah, it wasn't just a big hush-hush secret. Everybody knew about these boys. As a result, both the police department and Stoughton had a duty to determine the extent of the prior misconduct by M. Farwell and W. Farwell, and either failed to do so or ignored such prior misconduct. Despite knowledge of the misconduct by M. Farwell, W. Farwell, and Devine as head of the program, permit the Farwells to continue their malicious actions, and as such, the town and the PD were negligent. This negligence on the part of Stoughton and the police department led to the harm and ultimately contributed to the death of Miss Birchmore. Wherefore, the plaintiff prays that the judgment be entered against the defendants, Stoughton, and the police department for negligence in the amount that will fairly and adequately compensate for the loss of Miss Birchmore's life, and all other damages recoverable together with interest, costs, and such other relief as this honorable court deems appropriate. Count 5. Negligent supervision. Plaintiff's estate versus Stoughton Police Department. The plaintiff restates and realleges paragraph 1 through 44 as if fully set forth herein. In addition, the plaintiff states that this count 5 is derivative of count 1 and is derivative of the sexual abuse of the decedent as a minor while she was participating in the program. Stoughton and the police department owed the decedent a duty of care to protect her from the abuse and inappropriate contact suffered at the hands of officers Matthew and William Farwell and Devine. It was by virtue of their employment as officers with the PD that the inappropriate contact with Miss Birchmore was facilitated. Through the program, Stoughton and the PD provided the Farwell brothers and Devine access to the highly vulnerable population of minors involved in the program, including Miss Birchmore. As a result, Stoughton and the police department had a duty of care to protect those children from the foreseeable harms which could be inflicted by its employees. Stoughton and the PD breached this duty by failing to protect the decedent from the harms suffered by her over the duration of the program and thereafter. Wherefore, the plaintiff prays that judgment be entered against the defendants, Stoughton and the PD, for negligence in the amount of that will fairly and adequately compensate for the loss of Miss Birchmore's life and all other damages recoverable together with interest, costs, and such other relief as this honorable court deems appropriate. Now we're getting into count 6, assault and battery. And this is against all 3 officers and Birchmore's estate. And they're saying, paragraphs 1 through 50, this is a derivative of count 1 and deals with the sexual abuse of Sandra Birchmore as the minor while she was participating in the program. Says the defendants, the Farwell brothers and Devine, intentionally caused harmful and offensive contact with Miss Birchmore, a minor at the time, and that contact with the plaintiff, which continued after her participation in the program, directly resulted in the death of Miss Birchmore. The officers knew of the offensive nature of their contact with the decedent, who, when such contact was originally initiated, was a minor, and all 3 officers acted willfully and wantonly with the intent to conduct such sexual contact. As a result of the contact, the decedent suffered significant damages due to the continuous mental and emotional abuse and trauma that ultimately led to her alleged unaliving. Wherefore, the plaintiff prays, that it's be entered against the defendants for essay and battery in the amount that is fairly and adequately compensating for the loss, pain, and suffering and all of the damages recoverable with interest, costs, and such other relief as this honorable court deems appropriate. Count 7 is the Birchmore family versus defendants Matthew and William Farwell and Devine, along with Stoughton, the town of Stoughton, and the police department. It's saying the plaintiff restates and incorporates by referring paragraph 1 through 54 as if they are fully set forth herein. In addition, the plaintiff states that this count 7 is derivative of count 1 and derivative of the essay of the decedent as a minor while she was participating in the program. The defendants each failed to protect the decedent from the misconduct as alleged herein. All defendants were negligent and contributed to the death of Miss Birchmore. Facts. As a result of the above negligence and misconduct, Miss Birchmore suffered significant trauma and emotional distress as caused by the negligence of the defendants during her lifetime, at least from age 13 on. Such significant and emotional distress caused her to seek additional mental and emotionally psychological help as it exacerbated her underlying mental and emotional issues. This emotional distress arose to such a level that it significantly affected Miss Birchmore's relationship with her family and ultimately overcame Miss Birchmore's ability to cope with life and will to live, and led to her allegedly unaliving herself. Since this has since now this is being investigated as a homicide, those parts probably have changed because it's not being looked at as that necessarily anymore. But at the time when this was filed, it was still being looked at like that. Under the above circumstances, her family has suffered significant emotional distress upon finding that the 10-year period of SA and mistreatment exacerbated Miss Birchmore's underlying psychological issues and was the alleged cause of her unaliving herself. Due to the significant emotional distress suffered by the family of Miss Birchmore, has suffered significant harm and loss. Wherefore, the plaintiff demands judgment. Not praise for judgment, demands judgment and damages against the defendants Matthew Farwell, William Farwell, and Robert Devine, along with the city of Stoughton and the police department, in a sum to be determined at trial, plus interest, cost, and attorney's fees. Count 8. Negligent infliction of emotional distress. This is again versus Sandra Birchmore's estate versus the Farwell brothers, Devine, town of Stoughton, and the police department. They're restating everything from 1 through 62 as if it was written. It is derivative of count 1 and the essay that Birchmore received while she was a minor participating in the Explorers program with the police department. The defendants each failed to protect the decedent from the misconduct as alleged herein. As a result of the above misconduct, Miss Birchmore suffered significant trauma and emotional distress as caused by the negligence of the defendants during her lifetime, from 13 on. Such significant emotional distress caused her to seek additional mental and emotional psychological help and has exacerbated her underlying mental and emotional issues. The emotional distress arose to such a level that ultimately came to Miss Birchmore's ability to cope with life and will to live that led to her alleged unaliving. Under the above circumstances, any minor would have suffered similar emotional distress after a 10-year period of SA and mistreatment. Wherefore, the plaintiff demands judgment and damages against the defendants, in sum to be determined at trial, plus interest, costs, and attorney's fees. The plaintiff demands a jury trial on all counts so triable. This was submitted December 29th of 2022, and it is signed by Darlene Smith, the personal representative of the estate of Sandra Birchmore. Remember, Darlene Smith is her aunt. And then it's got the lawyer's information. So that is the civil suit that has been submitted in the Sandra Birchmore case. We are still hoping there is a criminal suit as well. There needs to be criminal charges in this. I think civilly they should have to pay as well, but there needs to be something in each of the courts, because this is disgusting and uncalled for. And nobody, as an officer, a town representative of the police department, none of this should ever happen. And it's not great questioning all that are in charge, and that everybody with authority has questionable behavior. How do you live in a place like that where no one can be trusted? Please keep this family in your prayers. We will continue following this case, and I will see you in the next one.